Hi everyone, my name is Sommer Ingram Dean. I am the staff attorney at the Student Press Law Center in Washington, D.C. I'm going to share my screen with you guys and tell you a little bit about what we do at the Student Press Law Center before we get started on today's presentation. The SPLC is a nonprofit organization based in Washington, D.C., providing free legal help and information to student journalists and their advisors on a variety of media law issues. Today, we're going to talk about access to records and meetings, but the center is ready to help you answer questions on pretty much any media law issues, including things like copyright law, censorship issues, libel and privacy concerns, and more. More information is available on our website, which is www.splc.org. Here you'll see the Get Legal Help button, which you can click on and submit an email or schedule a telephone call with one of our legal team members, and that's all free of charge. So let's get started on today's conversation. Freedom of information law. In America, the government is supposed to belong to the people. Freedom of information laws, also referred to as open records or open meetings laws, are simply one means by which the people have given themselves the ability to keep tabs on what their government and its officials are doing. As journalists, you have so much power to hold accountable members of the government, and better yet, those state actors that are even closer to you, your university administration and other employees. Having a working knowledge of freedom of information laws and how to utilize them gives you a major advantage when it comes to your reporting and when it comes to dealing with university administration or police who don't want to cooperate with your requests for interviews or information. Let's start by talking about who exactly is subject to freedom of information or FOI laws. Only public agencies or bodies are covered by these laws. This includes agencies within the executive branch of the federal government, including independent regulatory agencies. On a state level, departments like the DMV or entities like state colleges are subject to open records laws. On a local level, government agencies like the city council, city police, or your local school district must adhere to open records laws. Importantly, this means private bodies are not governed by open records or open meetings laws. However, some private bodies perform public functions and may be covered by FOI laws. For instance, some police departments at private universities exercise arrest powers and therefore are covered by open records laws, even though they are technically private bodies. There may also be other ways to get information from private entities outside of open records laws, and we'll discuss those later in the presentation. Today, we'll talk about three types of freedom of information law. Open records law is where we will spend most of our time, and there are laws on both the state and federal level. The second type of FOI law is open meetings law, and again, you have laws on both the state and federal level. Lastly, we'll discuss what we call pocket FOI laws, which often apply to private bodies through receipt of federal funding or some other government benefit. Let's start with open records laws. Generally, open records laws say that all records generated are presumed to be public unless they are specifically exempted by law. These are records that are either created or obtained by an agency and are under agency control at the time of the request. Most laws require a public official denying access to these records to furnish in writing a legally justifiable reason for the denial. If your request is denied, most laws allow the decision to be appealed to an ombudsman or an attorney general or some other higher body. As I mentioned, there are open records laws on both the state and federal level. State open records laws are the laws you'll be using when you are trying to get records from your school. If your verbal request is denied, it's important to document the date, the name and the title of the official you dealt with, and their response to your request. The Reporters Committee for Freedom of the Press publishes an online version of its Open Government Guide. This is an excellent starting point if you are trying to find your state's open records or open meetings laws. The Reporters Committee has broken down the law of each state into sections that you'll be able to click through and find out things like what records are and are not subject to state law, how to request the records, and any sanctions for non-compliance on the part of the agency. Freedom of information law at the federal level applies to all records created, possessed, or controlled by a federal government agency or maintained by an entity under government contract. These are agencies like the Department of Justice, the Department of Education, the Department of Transportation. FOIA does not apply to Congress, the federal courts, private corporations, or federally funded state agencies. However, documents these bodies create that are then filed with a federal government agency may become subject to the Act. Agencies frequently require open records requests to be submitted in writing, but you can always try a verbal request first. Although FOI laws operate under the assumption that records should be made available to the public if the agency possesses them, there are no requirements for agencies to create something that does not already exist. For example, if you are wondering about certain data that the agency does not have compiled in the way you had imagined, the agency is under no obligation to create the record with the information in the format you prefer. Agencies also do not have to conduct further research or add explanatory materials to any records they turn over to you. Again, the purpose of the open records laws is just to give the public access to the information. You have to do the work yourself to decipher what the records may mean, and that could include interviewing members of the agency based on what information you get from your open records request. Let's talk about the mechanics of actually requesting records. Making a public records request is fairly simple. You simply ask the government official you think keeps the record for a copy of the record. Asking professionally and politely will, of course, go a long way. Sometimes the government agency or the law will insist that the request be in writing. Also, a written request may be advisable where you know the agency you're dealing with does not want to provide the information. In such cases, your written request will be the start of a paper trail of evidence that you might later have to point to should the agency unlawfully deny your request. Filing a written request is a simple matter of writing a letter. It doesn't have to be addressed to the actual individual who has physical possession of the documents, because that is often a clerk or secretary. It's sufficient to direct your requestment to the head of the department, the agency's Freedom of Information coordinator, or another person in a similar position. The Student Press Law Center's website has a one-of-a-kind automated letter generator for requesting public records that makes creating a letter tailored to your state law as easy as filling out a short form. To produce a formal records request ready for mailing, all you need to do is have a reasonable description of the records you're looking for. You don't need a specific document number or an exact date, but the more precise your description is, the better. Add that along with the name and address of the government official you believe keeps the record you're looking for, and you're good to go. Here on the screen, you'll see examples of some of the parts of the form that you will be asked to fill out. You just plug that information into the blank fields, and at the bottom, click the button that says Create Letter, and the system will produce a PDF version of a letter that you can download and then mail to the appropriate person. So what happens next? State law will normally prescribe the amount of time allotted for the agency to get back to you once you've sent in your request. Within that time frame, the agency, or in your case, probably the school or university, must either provide you the records or respond in writing letting you know that the records are exempt. If the information can be provided while redacting other information, the agency is required to do so. Courts have ruled that information regarding students in these documents that may be protected by other privacy laws can legitimately be redacted while still releasing the information sought. If you believe that your request has been improperly denied, you can always call the SPLC and have one of our legal team members look over your request. We will look over your request, the school or agency's response, and the applicable law and guide you on what your next move should be. Generally, if we feel that the agency is in the wrong and they should release the records to you, we will advise you to contact the record keeper and politely cite the law. If that doesn't work, the next steps are prescribed by individual state laws. Sometimes there is administrative appeal available, meaning you can appeal the agency decision to a state ombudsman or something of the sort. In some states, the only avenue to dispute their refusal is to take them to court, which has been done by student journalists but is a lengthy and costly process. There are other ways besides the strictly legal avenues to put pressure on your school or on an agency to release records. You can always publicize the fact that you have requested certain records. You can publicize their denial and exactly what they've said to deny your request, and editorialize on why not just student journalists but the public in general deserves access to these records. Remember, we said that a public body must make its records open for public inspection unless it can point to a statutory exemption. I want to discuss some of the more common categories of information that are claimed as exempt under the Freedom of Information laws. It's important to know that while many of the exemptions you'll find are quite legitimate, there are some that should raise a red flag when they are cited. This slide lists a few of the most common exemptions that you'll see cited when requesting records. Anytime you're requesting records that may interfere with police procedures involving ongoing criminal investigations or otherwise jeopardize police strategy, you will likely not get access. This is because there's always a balance between the public's legitimate right to know what government actors are doing and the legitimate interest in not interfering with safety-keeping missions of law enforcement officers. Another common exemption you'll hear is exemptions for some personnel records that talk about hiring, firing, or disciplining. These records are often protected by other federal privacy laws. Lastly, you'll hear a lot of talk about education records. Records must meet two criteria to be considered education records. First, the records must include information that is directly related to a student. The most obvious example of that would be your individual grades in each of the classes that you're taking. Second, the records must be maintained by the school. That brings us to FERPA. For those of you who aren't familiar, FERPA is the Family Educational Rights and Privacy Act. This law is probably the most commonly cited exemption that we get questions about at the SPLC, and most of the time, the institution is misapplying the statute. The Department of Education has repeatedly described the statute as a narrow one that protects only the confidentiality of students' education records. The law was enacted in order to give students rights with regards to their grades and other information and to keep them from being disclosed without the student's permission. One part of the law penalizes schools that release these education records without student or parental consent. The other part of the law requires schools to provide students or their parents with a copy of their education records if requested to ensure that everything is accurate. This should have been fairly straightforward, but time and time again, schools have used this statute to hide information they don't want getting out to the public. Schools have come to misunderstand FERPA and use it to prevent them from providing the public even with an anonymized factual description of disciplinary events or safety problems involving students. As a result, parents and members of the media and inquiring members of the community are often told that the school cannot describe any bad incident that has happened at the school or divulge whether anyone was punished. This is not true. FERPA does not protect disclosure of general information that just so happens to relate to students. Therefore, it does not apply to disclosure of information derived from a source other than education records. In other words, as long as the school itself is not being asked to provide the contents of a school-maintained record, FERPA does not prohibit release of the information. And it should go without saying that the student media does not count as the school itself. So, for example, while you may not be able to get access to a student's disciplinary record, as a reporter, you still have the legal right to interview witnesses of incidents, even if the incidents may be described in some record somewhere. If you get denied access, try to find examples of analogous information that has been released by other schools who have not been punished for releasing such information. Here are some commonly requested records that you will run into issues obtaining. Disciplinary records are usually considered exempt under FERPA and cannot be disclosed, although courts have varied in their rulings. However, certain disciplinary outcomes are not covered by FERPA, and this is important to note. The final results of a disciplinary proceeding involving a crime of violence or a non-forcible sex offense may be disclosed without violating FERPA. I'll say that again. The final results of a disciplinary proceeding involving a crime of violence or a non-forcible sex offense may be disclosed without violating FERPA. The school would need to reveal the outcome of the proceeding, the name of the student who committed the offense, and the violation committed. Sexual assault records are another doozy when it comes to obtaining access to them. In 2017, the University of North Carolina at Chapel Hill refused to release records of people found responsible of sexual misconduct by the university, claiming that even though the documents were FERPA exempt, the university retained discretion over whether to release the documents. The North Carolina Court of Appeals ruled that a university does not have discretion on whether to release information otherwise subject to open records laws. When it comes to employee misconduct records, a clear majority of courts have ruled that documents discussing employee misconduct are not covered by FERPA, even if students were the complainants or the victims. Courts have also said that legal documents cannot be withheld just because a student is involved in the case in some way. So, for instance, a school cannot refuse to tell you how much a case settled for simply because a student may have been the victim or a witness involved in the case. Finally, Title IX records are notoriously hard to get a hold of. This information can be withheld based not only on FERPA, but a myriad of other privacy laws as well. Depending on the state, a completed disciplinary proceeding against an employee is often considered public information, but an incomplete or ongoing investigation is considered private. However, many state disclosure laws also include a general privacy provision that allows an agency to disclose even private records if the public benefit of disclosing the information outweighs the harm to a person's privacy. So, cases finding evidence of sexual harassment or assault by an employee are generally considered newsworthy. You can also confirm the existence of an official investigation at your school through the Department of Education, which maintains an online database of pending cases. Let's do a few real-world examples of things you may be curious about reporting on in your school publication. If you're wondering, how much money does my school spend on new football uniforms as compared to new textbooks? Or just how much does the school district superintendent get paid per year? You would request your school district's annual budget. This budget report should list the salaries of most school employees and would show you things like if the school paid for your principal's trip to Hawaii. The budget is also good for comparison on things like how much was spent last year on new books versus for the library versus new equipment for the football team. These budgets are issued annually and are open to the public. Copies should be available at the school district central administration office, but you can also check on the district website or at the public library. This information is available for public school students. Those of you at private schools can still ask, but school officials are likely not legally required to provide information on how your tuition money is being spent. This is where an IRS Form 990 can come in handy, which we will discuss later. If you want to know if the school buses at your school are safe, you can request school bus safety inspection reports. School bus safety vehicle inspection programs vary greatly from state to state. Some states don't have formal inspection requirements, but most will have at least something requiring school buses be inspected once or twice a year. School bus inspection records are usually maintained at the county level and should be available at the district transportation office. Because these records are so voluminous and they are allowed to charge you for the cost of photocopying, it may be easier and cheaper to set up a time to personally inspect the records yourself. Let's say you see some mousetraps near the food service line in the cafeteria. It sparks your interest and you want to know whether there have been any health violations at your school. Is your school meeting sanitation requirements? You would ask for your school's most recent cafeteria safety/health inspection report conducted by the Department of Health. Most food facility inspections are conducted at the local level by county or city health inspection officials rather than by the state health department. But you can also call your state health department and ask them where you can find the records you are looking for. Most schools require their cafeterias and other food facilities to be inspected at least once or twice a year. Other reports that are good to explore are accreditation reports. A copy of these should be available at the district central office or on the website. Most American public schools are accredited by one of 6 regional accrediting associations across the country. These accrediting associations are private nonprofits, but once the reports are sent to your school, they should be public information. Private schools are also required to make available their periodic accreditation reports as a result of Congress requiring that universities that participate in federal financial assistance programs show any current or prospective student on demand any documents describing the institution's accreditation, approval, or licensing. In these reports, you can find a ton of statistics. The typical report will contain information on how a school is doing in areas like educational support services, administration, financial resources, faculty, and physical resources. Another good source of statistics are your academic performance reports. These are legally required by the Every Student Succeeds Act, which requires every district publish report cards that must include, among other things, test score results, high school graduation rates, school funding information, and teacher qualifications. You should be able to find this via your state education department or your school district website. So now that we've hopefully sparked your interest in tracking down public records, let's turn to public meetings. Open meetings laws work pretty much the same way as their open records law cousins. A public body must provide notice of the time, place, and agenda of all official gatherings and allow the public to attend unless there is a specific exemption in the law that allows them to keep the doors closed. Generally, a quorum of members must exist. When you want to attend a public meeting, you need to show up, understand, and be prepared to explain the law. If officials tell you the meeting is closed, ask that your objection be recorded in the minutes of the meeting and leave. Immediately write down what happened and who you spoke with. Different state statutes may provide for administrative or judicial review. This is probably also a good time to contact a media law attorney or the Student Press Law Center for help. As with records, most open meeting laws provide provisions for appealing agency decisions. Non-governmental entities like university foundations may fall under open meetings laws when they are created by a government body, use public facilities supported in whole or in part by public funds, or perform traditionally governmental functions. Student government meetings are often not referred to in the statutes, but at a public school where student government is responsible for allocating student activity fees or other public money, or where decision-making authority has been delegated to them by the school, the open meetings law will often cover them. Finally, in addition to the general open record and open meeting statutes, FOI law also includes a number of miscellaneous provisions scattered about and often tucked into much larger pieces of state and federal legislation. Unfortunately, these pocket FOI laws, which sometimes require the disclosure of information by private organizations not covered by a general open record or open meetings law, often go undiscovered except by those who know where to look. For example, a federal law known as the Clery Act requires all colleges or universities that receive federal funds, which includes all public universities and nearly all private ones, to provide access to campus crime information. The Act requires colleges to gather an annual campus security report that includes statistics for the past 3 years on crimes like murder, sex offenses, robbery, assault, and certain hate crimes. This report must either be mailed or posted online or included in student handbooks. The Clery Act also requires schools to keep a daily campus police and security log. The logs for the most recent 60 days must be physically available on request for inspection during normal business hours of the police or security department. Logs older than 60 days must be made available within 2 days of the request. Finally, the Clery Act requires universities to issue timely reports, which deals with disseminating information about ongoing threats to students. The Department of Education monitors schools' compliance with the Clery Act. If you feel your school isn't accurately providing the required information, you can file a written complaint with the regional office of the Department of Education. No administrative appeal or court appeal is provided under the Clery Act, but it may exist under state open records laws. Some state campus crime reporting acts require even more detailed or different information than federal law. Another set of federal laws, known collectively as Student Right to Know Act, require all public and most private colleges to provide various bits of information about how they operate. Colleges must submit a report to the Secretary of Education, including things like academic standards adopted by a school, student graduation rates, the cost of attending the school, the availability of financial aid, and methods of award and dispersal. Schools must also submit to the Secretary of Education the number of students receiving athletically related aid, graduation rates of those students, etc. The report must be provided by July 1st of each year. You can also get this report from the Department of Education. Schools must also compile an annual report detailing revenues and expenditures that can be contributed to athletic departments and programs. All you should have to do is go to the school's business office or athletic department and ask for a copy. Now we get to the IRS Form 990, which I mentioned earlier. Fortunately, federal rules require most nonprofit organizations to provide a copy of their federal tax return, known as the IRS Form 990, which can provide at least a peek into the inner workings of such entities. The school's Form 990 provides general information about where its money comes from and where it goes, including, for example, a list of the 5 highest paid employees at a private school and their salaries. This is particularly important for those of you at private schools. You can get access to a school's IRS Form 990 report if the school is a nonprofit, as most private schools are. The report will provide information about a school's finances, including executive salaries, the amount of money the organization has taken in each year, including grants, a list of where the money was spent, information on the sale or purchase of investments like stocks and bonds, and more. You can get a copy of your school's 990 report from the IRS by contacting the IRS Service Center that serves your state, but that can take months to hear back from. So you can contact the school's business office to request access to a copy in the meantime. It must be made available to anyone who asks to see it during normal school hours, or you can visit guidestar.org. Remember, using FOI law to obtain information about how your government works is neither rude nor nosy. In America, we've decided that we want a government that is ruled by the people, not the other way around. If that idea is going to work, we, the people, must know what our government and government officials are up to. Freedom of information law is one important means by which that happens. Hopefully, this presentation helps you feel more equipped to go search for the records and information that are going to help you do reporting with an impact. Don't be scared off. Just another reminder to contact us at splc.org/legalhelp to schedule a call or send an email to our legal team if there are specific issues you're faced with.